Thank you all for joining us. I'm Rebecca Aicher, a project director with the AAAS Center for Scientific Evidence in Public Issues, also known as the AAAS Epicenter. We work to build trusted relationships between scientists and policymakers at all levels of government. And we work to make it easier for decision makers to access and use scientific information and for scientists to engage with policymakers at scale. So you can see that there are some linkages with evidence and policymakers, as well as evidence with judicial folks, but we really focus on local, state, and federal policymakers. We work on a number of different issues at the Epicenter. A few of those are PFAS, also known as forever chemicals. They're a class of thousands of human-made compounds that are persistent, bioaccumulating, and linked to human health issues. We also work on AI in public use, as well as green infrastructure and nature-based solutions for climate resilience, and a few other topics. So you can see we really work on a range of different issues. And if you're at all interested in talking more about that work, see me afterward, because that's not why we're here. We are here to talk more about scientific evidence in climate litigation, and to learn about some of the trends and where this might be headed in the near future. Just a reminder that this is an emerging field, so it's exciting to have two folks with us today who can really share about what we've seen, what we're seeing, and where we're headed. So we have two fantastic speakers and panelists. We have Dr. Paul Hanle, a visiting scholar and the founder of the Climate Judiciary Project of the Environmental Law Institute in Washington, D.C. He retired in 2018 from his position as president and CEO of Climate Central, and now is with ELI. Paul has devoted his 50-year career to public understanding of science and environmental conservation. We also have Dr. Delta Merner, who's the lead scientist for the Science Hub for Climate Litigation at the Union of Concerned Scientists. In her role, she provides timely scientific evidence to support legal cases that hold fossil fuel companies accountable for climate-related damages. Dr. Merner reviews legal communications for scientific accuracy, connects legal teams with technical experts, and leads trainings for scientists working at the intersection of climate science and the law. Unfortunately, we were supposed to have Sandy with us, but unexpectedly, she's not able to join us in the room today. And we really appreciate Paul for stepping up and joining us on pretty short notice. So welcome, and I think, Paul, you'll be our first speaker.
Thank you, Rebecca. Sandy sends her regrets, and I'm going to be stepping in using most of her slides, and she put together a really powerful program that's got a little fun in it too. So your first slide here, you see this fellow who is clearly a judge sweating, and he might be sweating because he's in a hot courtroom in a climate changing world, but more likely he's sweating because he has to deal with a case that has something to do with science and climate litigation. And so we're going to be talking a bit about science and litigation as we understand it, having developed program to educate judges, which I'll be telling you more about in climate science. And if I move this up, is it go to the next slide? No. Help me. Joel, sorry. I'm hitting random buttons here, and which one how do I clear it first? Okay, and then I hit this. If I want to go back?
Left and right.
Excellent, thank you. So just the roadmap, talk a little bit about scope and trends, climate science litigation in the very high profile case that was decided a few weeks ago, Held versus Montana, and some of the ways that judges engage with climate science, and then we'll quickly conclude. And first on scope and trends, if I can move this forward, thank you. The former president's science advisor, John Holdren, was fond of saying that in climate change, you either mitigate by reducing greenhouse gas emissions, or you adapt by accepting it and trying to live in a world that's hotter, or you suffer. And the balance of that is societal decisions that are happening. The analog in law, in the cases that we see, is mitigation cases involving efforts to control the amount of greenhouse gases. Adaptation and risk management, and the cases involve all kinds of ways that risk comes in and who's responsible for it, or impacts, and many of the cases are reducing or compensating for harm. The number of cases related to climate change has grown quite substantially. We sometimes say exponentially, although if you look closely, our colleagues at Grantham Institute have noted that there are two levels of where cases suddenly came in after 2007 and continued to be filed, and then suddenly there was a much larger number coming in around 17, 18. Total number is about 2,300 cases right now globally, and about 3/4 of those are in the United States. You can see around the world where those cases are, and Delta, my colleague, who will be speaking in a moment, is going to be talking more about the international aspects of it I am not as familiar with. But in the US, you can see where the cases have been filed. This does not break out by the kinds of cases. I'll show something of that in a moment, but you'll see some interesting concentrations. Note that DC has a large number, but that's because it's also the seat of the federal government, so a lot of them are federal cases. U.S. climate cases by claim. This data comes from the Sabin Center for Climate Change and Law, and as did the graph before. We've worked closely with them, and they have been very helpful in providing an inventory of cases. You can see how they're broken out the way they have broken them out. And the largest number are administrative law cases, national environmental policy, and the state national, they call them little NEPAs, the state environmental policy. But also the whole range, and the main point of this is to show the diversity of climate change cases. So science in litigation, go to Hanle versus Montana for a moment. And actually, let's step back for a minute. Climate science in general in cases is brought in when consideration of standing of parties who are bringing cases. And that's in both establishing, so standing has 3 requirements, and showing harm and causation are 2 of them, and science is brought to bear on that. The merits of the cases, there haven't been many climate cases that have been tried, gone to trial, a few big national ones, and none of the cases that more recently talk about climate impacts, with the exception of the Held case that I'm going to talk about in a moment. Courts may use all 4 types of attribution science, and talk about that, but particularly in remedies, source attribution, which is to say assignment of responsibility for emissions, and then impact and event attribution if there are impacts or even individual events, as there are in a couple of cases. What is the way, how can attribution be established is the question that judges have to weigh. In standing, one important basic foundational, I should say, case for climate was the Massachusetts versus EPA, 2007, filed in 2007, finally resolved 11, I believe. And the Commonwealth of Massachusetts challenged the US EPA because it would not consider a petition for including regulating greenhouse gases. And aspects of climate science were central in that. The climate scientists' declarations, which came in the form of amicus briefs and testimony, the IPCC reports, which are fundamental and were cited, greenhouse gas emissions accounting. So a lot of science woven into that case, which is the foundation of further litigation that was to come. And you can see the types of sources that are referred to. I'll note, and then perhaps there might be some interest in the Q&A later, that the nature of the science, the way that the science is presented is quite relevant to how these cases come before the courts. And attribution science is a significant and growing area of interest in cases. You can see the causal chain that's laid out here, which I would say, had looked at this morning and realized standing in, I would say that rather than putting source on the far left, I would simply put greenhouse gas emissions on the far left, which leads to global climate change, which leads to physical impacts that some of which create damage and injury called harm, and then going into the end of that causal chain, then asking the question, who or what is responsible for those effects, because that in the end is the question that the courts have to answer, and that's where source attribution comes in. In Held, there was a unique argument that was made. Montana's constitution singles out and elevates environmental rights. There are a few states, I'm told 7 states altogether, that one way or another consider environmental rights. And that bears on and it's cited there, plaintiffs have a fundamental constitutional right to a clean and healthful environment, which includes climate as part of the environmental life support system. And I believe that is from I can't read the blue. Can you? Yes, it comes from the Constitution of the state of Montana. And that came to bear when Held was being considered. Plaintiffs had to be determined to have standing, and the way that was established was by showing there were injury and to home and property and all sorts of ways that were contrary to the Constitution. And the other interesting aspect of the decision was that Montana had just passed a revision of its statutes that prevented state agencies from considering climate change when conducting environmental reviews. And so the implication of the decision was very evident when Judge Seeley said they have this constitutional right. The statute contradicts the Constitution and is therefore unconstitutional, and struck it down, even though hers was a declaratory judgment, which is what they had asked for. I think it's interesting, though, from our point of view, to look at the science in Held. There's about 1,000 references to science, one way or another, in that decision. And local climate impacts, obviously, is the majority. The judge said the science is clear. There are catastrophic harms to the natural environment of Montana. And I should note that Judge Seeley wrote more than 100-page opinion, and of that, about 50 pages was scientific argument. It was largely borrowed from the experts, particularly Peter Erickson, who was brought in to testify, and is a powerful discourse on the science of climate change that is now in law in her decision. Should mention the oil majors cases. Am I going on too long? Should I finish in about, can I have one more minute here? Thank you. The oil majors cases, which involve claims from states and counties and cities against fossil fuel companies. And the arguments are usually, not always, but most of the time they are that corporations engaged in deceptive sales and marketing, and it led also, because of what they sold, which is fossil fuels, to damaging climate impacts. And the defense is, yeah, but these are unique federal interests. The federal government has supported policies in advance fossil fuels for a long time. We'll see how that plays out. None of these cases has gone to trial. U.S. Supreme Court did say that they should stay in the states, and by doing that eliminated the possibility of what's called preemption of the cases, because in federal jurisdictions the emissions would be regulated by EPA. So I will just finish by noting that we've learned this, and we are conveying much of this to judges throughout the country in the U.S. through seminars and courses, and helping them to develop networks, particularly with scientists, and a curriculum that's peer-reviewed, 13 modules, that is written by the leading experts in climate and climate law, and a website that provides that. This is the curriculum. And if you want to know more about us, here's our contact information. Thank you very much. And Del, you're up.
Yes, excited to be here. I know that we're talking about a specific topic that isn't everyone's area of expertise here, but the interaction is really important. And I know over the last day and a half, I've learned a lot of different pieces that I feel like I can apply to the climate space as we're starting to think about education of scientists and lawyers and other folks kind of involved in the courts in this space from the work that you're all doing. And I'm hoping that we can have a discussion where we continue to kind of be learning where there's lessons learned and intersections between these two spaces. So just to start, I'll tell you a little bit about who I am and the work that I do. So I'm Delta Merner. I'm the lead scientist for the Science Hub for Climate Litigation at the Union of Concerned Scientists. The Science Hub for Climate Litigation is a newer project. We've been around for about 4 years now. And we have kind of 4 main areas that we work on. And I just wanted to run through these quick before jumping into the presentation. So probably the biggest area that we work on with the most amount of scientists is we work to catalyze and to conduct legally relevant scientific research. And you'll see kind of throughout my presentation, we've been doing a lot to kind of normalize the idea of legally relevant research within the community of scientists that we work with, and think about kind of how scientists can more readily engage in this space, and how we can appropriately kind of address some of the firewalls that folks have talked about between the legal community and the scientific community, so that we're producing really relevant science, but it's also science that's going to be held up and respected in the courts, and we have experts that'll be held up and respected in the courts. So that's one piece of the work that we do. We also do a lot, as so many of you do, around accessibility of science for lawyers, judges, and for communities. So I do a lot just really going to law classes and talking to law classes about climate science, and often I'm the first climate scientist that they've ever talked to, and they have the opportunity then to ask questions and really understand. And I'll say my first time that I was in a law classroom, it was a upper level class. It was environmental lawyers, and I was like, all right, I can start kind of at Climate Science 102, and I did my presentation and I finished. And the first question I got was, well, but isn't the Earth tilted, and that's why climate change happens? And I was like, oh, okay, I got to take a step back and make sure that we're really communicating the full story, right, and that people are really understanding. And of course, they're not going to have the full depth of knowledge, as we've talked about with so many of the different areas of expertise that we've covered over the last day and a half. But they need to understand the basics so they know what questions to ask, and they know how to engage experts properly. Another big piece of the work that we do is to really teach skills so that scientists can participate in the legal space around climate change. So this involves doing, we have some toolkits, which I'll talk about. We do workshops, and we do other kind of legal support for scientists as well. One of the things that seems like it might be a little bit unique from some of the forensic experts that have been, we've been hearing about over the last day and a half. In the climate space right now, a lot of the cases are really contentious, and especially around the cases that are against the major fossil fuel companies. And there's been a lot of backlash for the scientists who have participated in that. So as we get scientists prepared to be part of this space, we want to make sure that they're making good decisions and they're fully aware of kind of the risks and the benefits for participating kind of in these legal process. So that's something that we spend a lot of time kind of providing, again, the information so that the scientists can ask the right questions, and also connections to resources so that scientists can have access to lawyers if they need them, so that they can understand how to protect their communications, all of those pieces, so that they can really be effective as scientists in this space and not caught up in some of the politics around it. Finally, a big piece of what we do is to connect legal teams with experts in relevant technical fields. So again, this is a relatively new space around kind of this newer wave of climate litigation. And as was identified again earlier in the talks, a lot of times there's disconnect between maybe what the lawyers think they need or the expert that they want to call on versus who might be the best scientific representative for those ideas. And another misconception, I think, in climate change is most of the time you think that for a climate litigation, what you really need is a climate scientist. And that's a piece of it, right? These cases are describing climate science, but so much of these cases are kind of the impacts, and it's the science kind of around climate, right? So you have folks in health, you have statisticians, economists. It's the whole world of impacts that really, of those folks that need to be in there. Social science, which you'll see, I'll show you a little bit about, but even right now, the majority of our cases, I would say it's social scientists that we need who are prepared to be operating in these spaces. So also understanding when you talk about an area of expertise that it can be very broad and that there's a lot of needs that are there. So let me see if I can scoot this. So again, this is something that is not new to most of these folks that are in the room, but it was new for me as I was starting to come to this space as a scientist and saying, what does it actually mean for a scientist to be able to engage in the courts? So these are some of the ways that we work to pull scientists and to work with scientists and to inform them about the opportunities that exist in the courts. So the big thing, which we don't always think about, but is doing the litigation relevant research. And in the climate space, that's such a huge part of it. As we're talking about kind of, in some terms, emerging science, although climate change science is very well developed, kind of the impacts work is often kind of newer science that's being published. And we know that the legal timelines and the scientific timelines don't always align, right? So we need to start the scientific process moving along, because it can take years to do some of these studies, so that it's available as the legal community needs it. And so we want scientists who are thinking about this. And when I talk about litigation relevant research in the climate space, I often draw upon lessons from doing policy relevant research. 10 years ago, it was not natural for everyone. It wasn't really normalized for scientists to be participating in the policy space. There were still questions kind of about, how to do that, how to ask questions. And we've come really far in that realm, right? Folks, I think, pretty readily will engage in the policy space. And we're hoping to really normalize litigation as an outcome for research as well. So that's one of the big areas that we do work in. We also, in more of the direct support around cases, we do work on amicus briefs, and we help to advise folks who are interested in doing expert amicus briefs. We do some judicial workshops, although not nearly the expertise that my panelist here has. Scientists can also involve as scientific consultants, and this is something that very few scientists understand. I think most folks think that they've heard of amicus briefs, they think that, they can tie their expertise in, or they think they have to be an expert witness, and they're afraid of being an expert witness, right? But there's so much in between, kind of in that space of where lawyers need kind of education in the beginning of cases as they're happening. They need consultants to help understand what the realm of literature is that's out there. They need folks to talk through kind of the technical pieces, and those scientists often aren't the same one as the expert witness. So helping scientists understand that there's a big role kind of working with the lawyers in that consultant space. And then finally, of course, expert witness, which is, as so many of you all know, is kind of the pinnacle of what we picture as a scientist engaging in this space. And it's a very small number of people, but as Paul said, we now globally have over 2,000 climate cases, and those numbers are growing. In the last year alone, there was an additional 190 cases that were filed globally. And as those cases start to go to trial, we're going to need experts to participate in them, right? So right now, the few dozen or so climate scientists who are probably well equipped to be the expert witness is not nearly enough, right? We need to really be expanding those numbers.
It's a little bulky, the middle button. That's hard. Or maybe harder.
Oh, because I moved this thing. Okay, perfect. Sorry about that. So, as I said in the beginning, the way that we really talk with most scientists is around participating, is doing research that is litigation relevant. And in order to understand which research needs to happen that is litigation relevant, we did a research project where we actually did interviews with litigators from around the world, and we talked to them about what science they use, what science they wish they had in their cases, and where they think their cases are going, and what science they would need for that. So we created a white paper policy brief through the Climate Social Science Network, and also published a paper that was a little bit more condensed on research priorities for climate litigation. And of that, again, here you can see that there's a lot of different topics. These were the most discussed areas where litigators said they needed research, and some of it is maybe what you would be expecting, extreme weather attribution, impact attribution kind of at the local level, emissions tracking, some of the pieces that Paul talked about. A lot of it is also around corporate disinformation and greenwashing, corporate knowledge of climate change, economic damage, fair share emissions, which again gets into an interesting intersection of different disciplines to be able to think of the physical and the social together, and then a lot of fiduciary duties and understanding banks and other investors in this space. So these are just the most talked about topics. Through this research project, we actually identified nearly 100 research questions that litigators had, and we do have all of that published in the policy brief. In the shorter piece that we wrote, we prioritized some key areas that we think researchers should explore more around climate litigation. So again, these aren't research questions that we're asking for a specific case or for a specific lawyer, but these are areas of science that need to be developed in order to continue to move forward climate litigation. So those areas, again, the climate detection and attribution is a big piece, the obstruction of climate science and climate action, and then mitigation obligations. So understanding if you do need to mitigate, what does that actually look like? How do we actually reduce greenhouse gases? So this I'll move through quickly because it's similar to what Paul was saying. This is an image of the causal chain for us trying to put the science into kind of this legal perspective. And this is from a paper that I wrote with Jessica Wentz, who's at the Sabin Center, who is a lawyer by training. So helping to really understand how the science fits into these legal processes. And a big piece of that in the climate world is climate attribution science. And so just to say kind of more explicitly, climate attribution science, what it's really doing is it's asking the question of what role did climate change play in that event? So how much hotter is a heat wave? How much more flooding is caused from a hurricane, from really any climate event, right? Because as you have events that are happening, very few of them are 100% caused by climate change, but they're impacted and altered by climate change. And there's additional harms that are caused because of climate change, right? So attribution science allows you to tease that out. And then source attribution, the other piece, which again Paul mentioned, is really saying where did the greenhouse gases that caused that climate change, which then caused that impact, come from? So you can do source attribution that looks at different sectors, so the energy sector versus deforestation, carbon emissions come from a lot of places. You can do source attribution that looks at countries, so which countries are responsible based on different greenhouse gas budgets of emissions from countries. You can also do source attribution that focuses on companies. So the biggest studies and what a lot of the lawsuits in the US right now are looking at is databases around emissions from the major carbon producers, which are the 88 largest carbon producers, the companies around the world, and actually being able to break down what their greenhouse gases have been and how that then impacts these different events. So I wanted to give just one little example of one study. So this was done by Ben Strauss. This was published about 1.5 years ago, I believe. And this looked at doing this. There's no source attribution in this study, but there is event attribution. And they looked at Hurricane Sandy. And they specifically looked at just the impacts from climate-induced sea level rise and the additional damages that happened during Hurricane Sandy because of climate change-induced sea level rise. So sea level rise is complex, and it can be caused by the land subsiding, it can be caused by hydrologic changes in the nearby rivers, but you can isolate out, you can pull out, again, attribute what is happening from climate change, and then you can model and see how those impacts are changed for that area during different events. And here they found that approximately an additional $8.1 billion of damage was done because of the sea level rise from climate change during Hurricane Sandy. That translates to a flooded area that affected an additional 71,000 people. And this is a general approach that is just starting, but it's exciting to see kind of the way that the science is moving that can be really relevant to litigation. This is just some of the specific research questions. Again, you can look at all of the different questions in our report. The other pieces that science is really playing a big role in is understanding fossil fuel deception and obstruction. We continue to have new studies that come out to help us understand kind of when companies really knew about what was happening with climate change and the decisions that they made despite that knowledge. So this is a paper that came out in January of this year that further understands kind of ExxonMobil's global warming projections and how well they aligned with the science of the time. So since the 70s, they've really had a clear understanding. We also see more science around greenwashing, which I moved through very quickly, sorry. One of the big problems, so Paul kind of showed you a graph that showed where the climate litigation is, and of course there's more in the US because we're a very litigious country, and not all countries are, but there's also a real problem where there's a lack of scientific research that is happening in other places that can be the foundation of some of these cases. So something that is really important as we move forward is to make sure that we're diversifying where these studies are done. That is simpler said than done with attribution science. The current way that attribution science is done, it requires baseline data over a long period of time for you to model essentially what the world looks like with climate change and what it would look like without the different emissions. And we don't have that for everywhere, right? So we need to make sure that we're thinking about that and we're not creating inequalities because of lack of access to science in different spaces. So that's a really important conversation. There's a lot of additional work that needs to happen in this area. And again, we have tools where we're trying to pull researchers in. This is a toolkit that we have online for, it's called Research on the Record, to try to show scientists how they can be more involved in the climate litigation space. And then we also have a number of webinars that are coming up, which if you know anyone interested in this space, or if you all have expertise as folks who are studying the courts, as folks who are studying kind of how experts can present their information, judges who might want to share their experiences, please reach reach out to me because we'd love to kind of have that cross-learning and be bringing you in to talk to our scientists and help better inform them about this space. So if anyone wants to sign up for any of these, you can also sign up. We have other things on that page. So yeah, and you can reach out to me directly. Thanks so much.
Okay, so I think we're ready to start with questions, discussion, and I encourage you all to come up to the microphones and ask, but I know it's always hard to ask the first question, so that's my job. So we have 3 scientists sitting here. I'm a scientist, they're scientists, so we're going to start with a question around legality. So what legal arguments have you all found have been maybe most effective in recent climate litigation?
Well, I should say first, climate litigation hasn't really taken off very much. I pointed to Massachusetts versus EPA, and there were several other cases that were around that. In the federal courts, there has been only one trial, the Held trial, regarding impacts in state courts that centered directly on climate science. It was a broad range of impacts that they considered, that Judge Seeley considered, and that was a bench trial. It was only Judge Seeley. And I would say that when you read the opinion, and you also listen to, it was fascinating to listen to the arguments. Perhaps the most interesting question that was answered very effectively was how much of a contribution really matters in terms of heating the planet. Does Montana have a significant contribution? And the short answer on that, it turned out that Montana was 6th largest emitter in the US and had the same amount of emissions as Pakistan or Netherlands comparable, but the argument that seemed to hold sway was when the experts said, quoting the IPCC, even one additional ton of CO2 has a major impact on climate, adds to climate change, and the judge quoted that, and that seemed to be important.
Yeah, there's a lot of different cases, as Paul had talked about. In the US, the cases that we've been following most closely are the corporate accountability cases. And so these are cases that are against the fossil fuel majors, and these are actually, legally, these are mostly fraud and disinformation cases, so it's based on consumer fraud and the fact that that industry lied about kind of the impacts of their products when they knew what those were, so consumers continued to consume. So it's a very different legal argument than you might think. It's more closely related to some of the tobacco cases, and you can kind of follow those legal threads. So all the systems are slightly different, kind of for where folks think the strongest legal arguments will be. Internationally, most of the cases that we work on are human rights cases. So again, the case in Montana ties in some ways to human rights around, it was a youth case that was brought around kind of a right to stable environment. And there's federally, there's not protections for a right to a stable environment or climate necessarily in the US. It's still being debated, but the DOJ says there is not. But internationally, that's really different. So most of the cases that we're looking at internationally are human rights cases. They're starting to move through the courts, and actually this week we expect to hear rulings on a number of those cases, including Portuguese youth case. There was a case brought in Switzerland by older adults. So we'll see kind of what the impacts are of those legal arguments, but that's certainly the trend internationally.
See someone coming to a microphone.
It's not an area of my expertise, but I'm just curious if how much is there potential for litigation about the manufacturing of plastic from companies, and where is that in the US? I know that the EU seems to be moving away. Maybe that's due to litigation, maybe it's just policy and change, but I'm wondering about the United States and some of the companies here. Thank you.
Yeah, so I can speak a little bit to that. So the state of California is doing an investigation into plastics, and it's a disinformation case, so really kind of understanding the claims around recycling that were, when they understood that those claims weren't very accurate, and how they continued to push some of that. So there is litigation potential. Again, those are studies that are happening right now. There's certainly an understanding kind of that as you look at fossil fuels, that increasingly, higher percentages as fossil fuels are used less for transportation and electricity, it'll be used for petrochemicals. And there are folks, so I would point to CL, the Center for Environmental, yeah, there's an I in there, international law, but they have a number of folks that are on the ground in communities that are dealing with kind of the build out of petrochemicals right now. So we saw in Louisiana and West Virginia kind of a real build out from the fossil fuel industry to put more money into plastics and petrochemicals, and they're doing investigations to kind of understand the legal points around that right now.
Great, thank you. Go ahead.
So in the international cases, one of the questions that has come up is whether the standard of review should be, whether judges should be looking at consensus science as the science on which government should be basing policy, or the best available science. And I'm curious to ask you as scientists what your thoughts are on that question that's coming up in a legal context.
Yeah, so I think this is a really fascinating question, and I'd love to hear kind of other legal thoughts around this, because this is something that's truly at that nexus, right? It's that scientists can't answer this alone. It's really about kind of how the courts and science work together. So for most of the cases that we've worked on internationally, we start with citing the IPCC and really seeing where consensus science can shine. And if that can hold the whole case, which often, especially for these human rights cases that we're seeing, really all of the evidence that's needed is within the IPCC, and understanding, because it's often pretty blatant failures to really try to achieve Paris Agreement emission levels. So in my opinion, as much as possible, you want to be sticking with that. And a lot of that is, again, some of the conversation that we had earlier, but preventing the potential for kind of the battle of the experts from happening. So luckily at this point, most of the cases that we've seen, we haven't seen any cases that have actually challenged legally whether or not climate change is real, which is important, because I think there's fear that that will happen, but the courts, that has not been the dialogue at all of the courts. They've been, of course, climate change is real, and it's kind of moved on from there. Now, not all cases are based just on kind of the consensus science, and I think the case that's most important to cite is this case that is actually in the German courts, and it's company RWE, and it was brought by a Peruvian farmer, and that case is about glacier melt, and the case is saying essentially that emissions that were coming from this company in Germany, which is a small percent of the global emissions, but is still significant, that they should have to pay kind of appropriate, kind of the same percentage of emissions that they have towards a project that will address adaptation for potential flooding from glacial melt for these communities in Peru. And this is a really interesting case, and it hasn't gone to trial yet, but it continues to move through the courts, and it's based on a lot of science around climate change, but kind of a very particular study that actually comes out of some scholars at Oxford who are looking at the attribution science of this glacier melting. So this is a case where it's using kind of the newest science, and this case is really developed on that, and we'll see kind of how that moves through. But the reality is that attribution science hasn't really been tested in the courts. Climate attribution science hasn't really been tested in the courts.
Yeah, absolutely. I wanted to add to it also that there are two cases in U.S. courts that are attempting to make a connection of greenhouse gas emissions, climate change. to particular events. One of them is in Washington, the state of Washington, and the other in Puerto Rico. We'll see how attribution plays out in those cases. Let me go, though, back to the general question. If you think about how science works and how climate science works in particular, when you bring in cutting-edge science, or the term used was best science, but another way is newest, emerging science that might be construed as best, but also may be so transitional that it over time might not stand up, or, as Delta just said, be subject to the battle of the experts in a case. We have decided in teaching judges about climate science, which is a very important subset of, we don't make arguments, we do not have any partiality, we try to avoid as much partiality as possible, I should say. That there we say, and we reassure the judges, that we're teaching them mainstream science. We look, and this was the point I was making before, we cite climate assessments, consensus reports, and other kinds of things where the consensus of the scientific community is largely established. That gives them comfort. They work with that much better than if you're telling them what some of the most interesting, exciting science is that could well have a bearing on the cases. They may be curious about it, and out of courtrooms, we'll tell them about some of that. But for the most part, we try to stick to the mainstream.
One thing I think maybe just to add quickly for folks to why this is so important is because the IPCC, which is incredibly significant and people hear about it, gets talked about in the news, the IPCC is a document, it's not original research, it's pulling together kind of all of the research that's happening globally, and that happens every 7 years or so. There's some variation in that, but what that means is that when that report is published, and as it stands for the next 7 years, the reality is that that science is a bit dated, right? And as you have climate science that's moving very quickly, if you have a report that's a few years old and is citing all science that's a few years old, as important as that is, and that document is amazing because it is a consensus document where you have, you know, over 100 governments that are signing on to the summary of that report, it's incredibly valuable, but it's always behind the times of what's happening with the latest climate science.
And that sort of leads me to the question of uncertainty and how uncertainty plays into the uncertainty in the scientific research, how that plays into judges, the judicial interpretation of it.
Let me take the first shot and give it to Delta. But, you know, you think of uncertainty, and as you introduce, not you as scientists, but the general public, introduce the word uncertainty, the question arises, well, is it or is it not? Is there really an effect or is there not? That's often the immediate interpretation of uncertainty, whereas, as we know, uncertainty has a very well-defined scientific definition. And the use of that term, we talked about a number of times yesterday and today, the use of that term can be very misleading for, say, a jury. And so one thing that we feel is important is to define carefully what scientific uncertainty is to the judges, because they're going to be the ones who in the end will have to provide some guidance to juries when and if cases go to deliberation. And the definition's not so easy. This is part of Climate Science 101 education. So you just have to get in there and try to impart a degree of sophistication about what scientific uncertainty is, and that it is different from I'm uncertain as to whether climate change is real or not.
Yeah, so in those ways, I think that most of the people in this room kind of grapple with uncertainty in your own fields and what that looks like, how you present it. One of the things that's unique for climate change is that With climate science, we're dealing with a decades-long campaign from the fossil fuel industries to instill the idea that uncertainty means, as Paul was saying, that climate change isn't real, which is not at all what uncertainty means, but they've created this narrative for the public that very much aligns those two things. So as you're going into the courtroom, not only do you have to think about kind of how the general public thinks about the terms of uncertainty, and you have to be a good science communicator, which is really tricky, and I've been caught up in the courtroom around the uncertainty before. It's really hard because it's, you're using different language as a scientist versus kind of how folks are thinking about it, but you're also, again, kind of contending with, again, a very well paid for intentional disinformation campaign that is focused on making people think about uncertainty and climate change in a false way. So you need to understand that and make sure that that can be presented in an eloquent and scientific way to the courts as well. And we, I think, also need to get ahead of that within kind of other cultural understandings around climate change.
I'm sorry to break the news to us, but we're out of time. But I do want to end with one quick question, maybe a few seconds from both of you, about how you see scientists getting involved with judicial education. And then we'll end it, I promise.
That's great. So, and more broadly about litigation as well, but starting with judicial education. Is this thing on? Good. Sorry. What we have found is our project really is intended to link judges to scientists, and we have reached out to the scientific community through scientific leaders first, climate science leaders I'm talking about, and more as we have developed the program, more to younger and mid-career scientists. And we asked them if they're willing to give presentations to judges and otherwise to be trained in how one might present science to judges. And what we found is that almost universally, the scientists are enthusiastic about doing this. This is a safe place. They can talk to the court, but to be sure, it's not the court, it's the judges who are trying to learn the background information. And they can begin to develop a rapport. So we found that a process of building a web of connection between science and the judiciary is very doable, and we're developing mechanisms to do it. We've got a core of judges that reach out to communities, and they ask us for scientists to help them to present. We've got a group of young scientists who are working, have been trained by a group of judges and some extraordinary climate scientists and communicators to be able to talk to the judges, and we match them up. It's a very gratifying experience.
Yeah, and we have a similar kind of process, but kind of in the larger climate litigation space where experts can sign up with us. They can be part of the Science Hub for Climate Litigation, giving them access to skill shares, a network of folks, and then as we have opportunities that are coming up either for education, for research, or for kind of advising on cases or working with cases, we can share those opportunities in that. So yeah, so that's the main way.
Wonderful. Thank you both. Thank you all.